Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number Two. My name is Judge Terrence Holmes. I'm the presiding judge here at County Court at Law Number Two. You have been asked to come to court today for what is called an arraignment, and what the arraignment is just an opportunity for the court to tell you what you've been charged with and what your rights are and what your options are concerning your case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felony and misdemeanor. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they're convicted of the offense. Now, felony cases are divided into 5 categories. So we'll start at the top, work our way on down to the bottom. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is the capital murder, then the minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, you do not have to worry about those type of punishment because, as I mentioned to you earlier, your case is a misdemeanor case. Now, misdemeanors are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanors are cases that start in the JP court or the municipal court, which is the city court. They come to this court when a person is found guilty or they plead guilty or plead no contest in the JP court or the city court, and then they appeal their case. When they appeal, they get a whole new trial. We call it a trial de novo. So they get a whole new trial in this court. The range of punishment stays the same. And the range of punishment for a Class C misdemeanor is a fine only. Cannot be given jail time. You can only be given a fine. And the fine cannot be above or cannot exceed $500. Now, if a person fails to pay the fine, or if the fine was converted to community service and they fail to perform the community service, then the court can issue what is called a capias pro fine. That's a warrant for your arrest to either pay the fine or for you to sit out the fine in jail. If you sit out the fine in jail, you will receive $100 that will be credited toward the payment of your fine for every 1 day that you spend in jail on the case. Okay. Now, the next highest misdemeanor is a Class B misdemeanor. With the Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days in the county jail, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, the highest misdemeanor is a Class A misdemeanor. With the Class A misdemeanor, range of punishment is the minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such jail time and the fine. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called unadjudicated probation, unadjudicated probation. The other type of probation is called adjudicated probation, adjudicated probation. So we have unadjudicated probation and we have adjudicated probation. With the unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. You will not have a conviction on your record, and you may qualify for what is called a non-disclosure. A non-disclosure means that your record is sealed to the general public. That is, the general public cannot have access to the fact that you received deferred adjudication for this particular offense. Now, when I use the term, non-disclosure, sealed, that just simply means, as I mentioned to you, that the general public cannot have access. Now, there are certain governmental agencies that are listed in the Texas Code of Criminal Procedure that can have access. However, most of the public is the general public. So let's say, for example, you apply to a job at ExxonMobil. You have a non-disclosure for an offense, and ExxonMobil does a criminal background check. Well, they will not see the fact that you had this case and that you receive that you have a non-disclosure, because it cannot be disclosed to them because they're part of the general public. Okay. Now, the other type of probation is called adjudicated probation. Now, with adjudicated probation, it does result in a conviction record. However, there is a law that's called judicial clemency, which means that the court, the judge, has the discretion to set your conviction aside, which means that you will no longer have a conviction. Now, in order to qualify, three things has to happen. One, you have to successfully complete probation. Two, there cannot be any more time left on the probation. And three, the probation department has to successfully discharge you off of probation. If those three things happen, then the court can set your conviction aside and you will no longer have a conviction on your record. So if somebody try to do a search on you, the conviction is not there because you received judicial clemency. However, if you get a subsequent conviction, that is, if you get another conviction later on for something, another offense, then the case that you received judicial clemency on, it can be resurrected, revived, or brought back up, and it could be used against you. And if you try to get a license with Child Protective Services, they can deny you, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Okay. Now, everyone that's here for a case should have a clipboard. Okay? Who does not have a clipboard? Everyone have one? Okay. Okay, I'm going to go over that information on that clipboard with you. Okay? Now, that first page is titled Judge's Explanation of Rights to Defendants Without Attorney. It looks like this. Okay? Now, I will constantly refer back and forth to this page. It states, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you would like to have an attorney, you may require, but if you cannot afford to hire an attorney, you may ask that an attorney be appointed to represent you. And number three, you may represent yourself. That is, you may waive your right to an attorney and represent yourself. Now, the first one sentence paragraph under number three states that if you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you will be given another court date from today to give you time to hire your attorney. The second one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. But you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Now, the financial questionnaire is also on the clipboard. It's a document that is titled Jefferson County Affidavit of Indigence, or maybe just Affidavit of Indigence. It's a 3-page document. You would have to fill out the entire first page. Now, this is only for people who is applying for a court-appointed attorney. If you're not applying for a court-appointed attorney, you don't have to worry about this document. But if you are applying for a court-appointed attorney, you'd have to read and fill out the first page. And then you go to the second page, and on the second page, you fill out the top portion that is titled Defendant's Oath. And then you'll fill out the middle portion that's titled Unsworn Declaration by Defendant. Okay? So again, on the first page, you'll fill out the entire first page. Okay, the top portion and then the bottom portion. And then you go to the second page, and on the second page at the top, it states Defendant's Oath. You'll fill out this section that's titled Defendant's Oath. You know, basically the other thing they're asking for is today's date and your name. Okay. And then the bottom portion says Unsworn Declaration by Defendant. You'll fill that out, and it asks for your address, your name, your address, and that type of information, and the county in which we live. All right. And then this is only for people who will be applying for a court-appointed attorney. All right. Now, going back or referring back to the first document, Judge's Explanation of Rights to Defendants Without Attorney. That third one-sentence paragraph, the little number 3, is for people who will be representing themselves. Okay. If you or waiving your right to an attorney or giving up your right to an attorney, you are entitled to represent yourself. And if you represent yourself, it just simply means that you will be your own lawyer. And because you will be your own lawyer, just like a lawyer would have an opportunity to talk to the district attorney's office. In fact, we have a prosecutor here. He's an assistant criminal district attorney. Attorney Sammy Mazradian, you'll be allowed to talk to him because you are your own attorney. You can talk to him to see if you can work out something on your case, or we call it a plea bar, or negotiate on your case. Okay, now this one-sentence paragraph states, the third one-sentence paragraph states that you may not speak to the prosecutor unless you first fill out a waiver of counsel. The waiver of counsel, now this is only for people who will be representing themselves. The waiver of counsel is a 1-page document on the clipboard. It's titled Waiver of Counsel for purposes of entering guilty plea or proceeding to trial. You'd have to read this entire document and then sign and date. Okay? This is only for people who will be representing themselves. Now, for those individuals who will be representing themselves, there's a paragraph in block form below that third one-sentence paragraph. And this is only for people who will be representing themselves. It states that be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, if you are representing yourself, this next one-sentence paragraph, last one-sentence paragraph states that you may change your mind at any time and request that an attorney be appointed to represent you. So, for example, let's say you're representing yourself, and let's say you would like to talk to the prosecutor, and let's say you would like to see if you can, the prosecutor would offer you a fine in the case. Okay, And then you talk to the prosecutor. The prosecutor say, well, I'm not gonna offer you a fine. We're gonna offer maybe probation. And you say, well, I don't want probation. I want to change my mind. Judge, I would like to see if I qualify for a court-appointed attorney. Okay? So in essence, you may change your mind at any time. Okay. Next, at the bottom of this document, everyone that's here is going to put your initials and sign this. You'll put your initials on one of the 5 lines on the side, depending on what category you're in, and then you'll sign and date. Now, at the bottom of this document, it states defendant's choice. Mark initials next to one choice. Okay, so everybody's gonna make a choice. Now, if you would like to hire your own attorney, then you'll place your initials on the first line to the left. Then you'll sign the bottom where it says defendant, dated today's date, June 30th, and then you'll stop. And this is the only document that you would have to sign. Okay? Now, if you have already hired an attorney, then you'll place your initials on the second line to the left, and the name of the attorney on the line to the right. Then you'll sign at the bottom, today's date, dated, and then you'll stop. And this is the only form that you would have to sign. If you would like to apply for a court-appointed attorney, then you'll place your initials on the third line to the left. You will sign, date it, and then you'll fill out this form that is titled Affidavit of Injuries or Jefferson County Affidavit of Injuries, which is a 3-page form. You fill out the entire first page. You go to the second page, fill out the top portion that's titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. Now, if you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line at the bottom to the left. You'll sign, date it, and this is the only form that you would have to sign. If you would like to represent yourself or waive your right to an attorney, then you'll place your initials on the fifth line to the left. At the bottom, you will sign and date it. Then you would read and sign the document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Okay? Do we have any questions? Okay. Now, I'm going to give you time to fill out this paperwork. But at this time, I need to go over some rights that you have. It's some more rights that you have. First of all, when a young man is sitting in that area, we call that the jury box. Okay. Now you have a right to have a trial by jury. 6 citizens from Jefferson County will be selected to serve as jurors in your case. The reason why it's 6, I know you see 12 chairs, but the reason why it's 6 is because in county court in Texas, we have 6 men, a 6-person jury. In district court, felony court, you have a 12-person jury. Okay? So 6 individuals will be selected to serve as jurors in your case. And what they will do is they'll listen to all the evidence that's presented by the state and by the defense. They will listen to the arguments of the state and the defense, and then they'll go back into the jury room to deliberate. And then they'll decide to find you either not guilty or guilty. You also have a right to waive, which means give up. You have a right to give up your right to have a trial by jury, which means you will not be having a trial by jury. You still can have a trial. The trial that you can have is called a bench trial. It's a trial by judge. And the reason why they call it a bench trial is because the judge sits on the bench. So they call it a bench trial. Now the judge will be the judge and the jury in the case. The judge will listen to all of the evidence that's presented by the state, by the defense. The judge will listen to the arguments of the state and the defense. And then the judge will apply the facts to the law and decide to find you either not guilty or guilty. Now, if you do not want a trial, and let's say you just want to enter a plea of guilty or no contest, okay? Then at that point, you have an opportunity, if you represent yourself or your attorney, who will represent you, they'll have an opportunity to talk to the prosecutor, okay, to see if a plea bargain can be worked out. And if a plea agreement is worked out, let's say you wanted probation and you got probation, or let's say you wanted a fine and you got a fine. That's what they offer. And then what happens after that? It's an agreed plea agreement. Then it goes before the court, the judge. The judge can do one of two things. The judge can either accept or reject the plea bargain agreement. Now, if the judge rejects your plea bargain agreement, that is, let's say you wanted a fine and they give you a fine, and they offer a fine, goes before the judge and just say, well, I'm not going to follow that plea bargain agreement. Well, you can withdraw, which means to take back your plea agreement. In essence, you can say, well, judge, since you're not following the agreement that I made with the state, I take back my plea. In essence, I'm not pleading no contest, or I'm not pleading guilty to the charges. Okay? You have a right to do that if the judge does not follow your plea bargain agreement. Now, if the judge does follow the plea bargain agreement, and if you decide, say, within 30 days, you think that you've been wrongly convicted, or the court committed an error by convicting you, and you would like to appeal your case. So, if you'd like to appeal your case, you have to go back to the judge who follows the plea bargain agreement, and the judge has to give you permission to appeal your case. If the judge does give you permission, then your case will leave this court right here, and it'll go right upstairs to the Ninth Court of Appeals. There are 4 judges or 4 justices, okay? They will review your case, and they can do one of two things. They can grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty, case over. Or they can send the case back down to this court and order this court to give you a holding trial. Or if they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal your case to the Texas Court of Criminal Appeals, which is located in Austin, Texas, and it is the highest criminal court in the state of Texas. Now, you would have to file what is called a pro se petition for discretionary review. Pro se means self, representing self. And I'm petitioning, which means I'm asking the Texas Court of Criminal Appeals to review my case. Why? To see whether or not my appeal should have been granted, or whether or not this court committed an error by convicting me. They can do one of two things. They can grant or deny your petition. If they grant your petition, they can simply find you not guilty, case over. Or they can send the case back to the Ninth Court of Appeals with orders, or they can send it back down to this court with orders. All right. Now, if they deny your pro se petition, at that point, your conviction will stand. Now, the other right that you have is, that's on an agreed plea bargain. Now, let's say you and the state have talked, you and your attorney in the state have talked, and y'all have been unable to reach an agreement concerning a plea bargain, but you still want to plead guilty or no contest. Then if that's the case, you have a right to go before the judge and let the judge decide what the punishment is going to be in your case. We call that an unagreed plea bargain agreement. Okay, you have a right to do that. So if you don't like what they're saying, you have a right to go to the judge to let the judge assess the punishment. All right, that's called an unagreed plea bargain agreement. Now, the other right that you have a right to have witnesses to come to court. Now, originally appointed back then, there's a chair back there with a microphone in front of it. And that chair, that area is called a witness stand. And the witness stand is a place where witnesses, they sit in a chair and they testify in a case. They can testify for you or against you. And if you are representing yourself, you can ask them questions. Or if you have a lawyer representing you, your lawyer can ask them questions. We call that either direct examination or cross-examination. Now, you can either waive or give up, which means to give up your right to have witnesses to come to court to testify on your behalf. Now, what that means is this. It means that you will not be calling witnesses. Does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case. Now, you also have what is called a Fifth Amendment right against self-incrimination. What that means is this. The Fifth Amendment of the United States Constitution gives citizens the right to remain silent. What that means is this here. The state, the government, the district attorney's office cannot force you to take the witness stand and testify against yourself. Okay? And if you think about it for a minute, it makes sense. And the reason why I say it makes sense is because of this here. The state, the district attorney's office, the government, they have the burden to prove that you committed this offense beyond a reasonable doubt. They have the burden to prove that. You do not have to prove yourself guilty. Think about it. You don't have to go and say, I did this, that. You don't have to prove yourself. That's their job. Okay, the burden never shifts to you. It stays with them. Okay, now you can waive or give up your right against self-incrimination. If you do so, that simply means that you will be taking a witness stand. All right. Now, the other right I need to talk to you about is your right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you in their files, right? You have a right to see your statements, witness statements, police reports, lab reports. You have a right to see video recordings, photos, listen to audio recordings. You have a right to have access to documents, instruments, whatever evidence that they have, you have a right to have access to that. Okay, now you can waive or give up your right to have discovery. And if you're waiving or giving up your right to have discovery, that simply means that you would not be having access to the evidence that they will be using against you in their case that they have against you. Okay. Now, everyone that's here, charges have been filed. You have been arrested. You have been booked in the county jail. You have been released from county jail and you're out of jail on a bond. You're either out of jail on a cash bond, which means that you paid the full amount of the bond to get out of jail, or you out of jail on a surety bond, which means you paid a bondsman a percentage of the bond to get out of jail, or you just may be out of jail on a PR bond or a personal recognizance bond, which means that you did not have to pay anybody to get out of jail. You was just released under your own personal recognizance with a promise to appear here today. I've said that to say this. Every day that you spent in jail can be used as credit towards your punishment. The operative word is day, and I'll explain that to you. Let's say you were booked into jail at 11:59 p.m. last night. And let's say you booked out of jail 2 minutes later at 12:01 a.m. this morning. Guess what? You get credit for 2 days. Why? Because it's 2 different days. One day was Monday and the next day was Tuesday. 2 minutes later, right? So you get credit for 2 days. Now, I say that to say this. Now, let's say you spent 5 days in jail. And let's say you talk to the attorney, the DA's office, and they offer you to serve 5 days in jail. Guess what? You don't have to serve any more time in jail. Why? because you'll be given credit for the time that you've already served, which is 5 days. Now, if you serve 7 days in jail, and no, if they're offering 7 days in jail and you serve 5, that means you only have to serve 2. Why? You already served 5, so we subtract 5 from 7, that leaves 2. Now, every day that you spent in jail, you also you are credited $100 per day that will go towards your fine and court costs. So if you spend 5 days in jail, that's $500 that can go towards your court costs. If the state is offering you fine and court costs of $500, that means you will not have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. If they're offering fine and court costs of $700, you spend 5 days in jail, which is $500. That means you only have to pay $200 because we will subtract 5 from the 7, that leaves 2. Now, you'll be required to pay the balance of $200 on the day that your case is taken care of. If you cannot pay it, no problem, because we can put you on what is called a payment plan, where you can pay it off in small monthly installments until it's paid off. But let's say, even if we put you on a payment plan, you still would not be able to pay it off. No problem. Then we can convert your fine and court costs to community service. So for every 1 hour community service that you perform at a nonprofit organization, $12.50 will be credited toward your balance. So for example, if you work 8 hours one day, that's $100. That's going to be credited toward your fine and court costs. So in our scenario, you owe $200. You work 2 8-hour days community service. It will pay off the balance because that's $200. Okay. Now this court. Well, next I need to talk to you about the programs that the district attorney's office has. If you have not had cases filed against you before, this is your first time having 1 or more cases filed against you, well, the district attorney's office has a program that's called pretrial diversion. With pretrial diversion, they will dismiss your case, and then you can get it wiped off your record like it never happened. Okay? Now, in order to qualify for the program, 3 things. 1, it has to be your first time. Okay, getting in trouble and having 1 or more cases filed against you. 2, it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. And 3, you have to have an attorney to help you with the application process. Now, the attorney could be court-appointed. Don't have to be hired. You have a court-appointed attorney. Tell them you want to get in pretrial diversion. They send a letter. If you get in for pretrial diversion, you complete the program. Guess what? Case dismissed, and then you can get it wiped off your record. We call that expunction. Okay, pretrial diversion. Now, let's say you're a veteran of any one of the branches of the United States military. The district attorney's office has another program that's called Veterans Courts for veterans only. With that program, you get into the program, you complete the program, they dismiss the case, you get it wiped off your record. Okay? That's for veterans only. And it's not limited toward you having any type of particular offense. You just have to be a veteran to get into the program. Okay. Now, this court, County Court Law Number 2, Jefferson County, Texas, has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that God led me to start within the first 100 days of taking office in March of 2017. In that program, the program is designed to address the issue of what we call recidivism. Recidivism, where people commit crimes over and over. Okay? And so with that program, the program, as I mentioned to you earlier, is designed to address the issue of recidivism. Yeah. What? Huh? Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up if you need to shake it off. Yeah, you can stand up Okay. So, you gotta pull your pants up though. Okay? All right, now, the program, as I mentioned to you earlier, is designed, it's called the CSI program, stands for Community Safety Initiatives Program, and God led me to start within the first 100 days of taking office. That program, as I mentioned to you earlier, is designed to address the issue of recidivism when people commit crimes over and over. And we have, the way the program is designed with partnership. We have a partnership with various agencies in our community. One of the agencies that we have a partnership with is Spindletop. And Spindletop, they are a local mental health agency in the Southeast Texas region. They have the expertise, personnel to address mental health issues. In fact, we have a mental health deputy who's going to come to you in a little bit and talk to you a little bit more about the program. But basically, what Spindletop can do today, they can do an interview either in our jury room, at their facilities, by telephone or by text message, whichever is convenient for you. They also have the ability to do an assessment. An assessment is where they will determine what your mental health issue is. Okay, they have doctors there who can do an assessment and make a determination. And then they can develop what is called a treatment plan to address your mental health issue. Now, if you have issues with drugs or alcohol, well, they also have a drug and alcohol recovery program that is called ATAR. ATAR is the acronym, A-T-A-R, ATAR, and it stands for Addiction, Treatment, and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR. OSAR, O-S-A-R, is an acronym that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are drug and alcohol recovery program. And what they will do, they can do a screening, which is an interview. They can do an assessment to determine what your drug and alcohol problems are. And then they can develop a treatment plan, either outpatient or inpatient treatment. Now, if you are unemployed or you're looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Now, Lamar University has a program that is called CICE, and it stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, or the chemical industry. And what they will do, they will provide training in any one of those areas. And then after you get the training, they will help you to get a job that you're trained in. And I'll just put a pin in it right there, help you to get a job. For example, let's say you trained in a certain area, you didn't go through CICE and you've been applying to places, they've been turning you down. Okay. But CICE go in there with your name, same place that you went to, you get hired, right? Because they have the reputation. They're reputable, okay? They know that the training that you got from CICE and the programs that you went through, you're going to be a good employee. Okay, so the program is a good program. Now, let's say you do not have a high school diploma, or you do not have a GED. Well, Spindletop as well as CICE has a GED program where you can get your graduate equivalency diploma. Okay? And so now all of these programs that I just mentioned to you are free. Does not cost you anything but time. And I like to say that in this court, We don't just give time. Okay? We take our time. And that simply means that we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I like to say that when you come to County Court at Law Number 2, Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individual that comes before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know. And then we can direct you and give you the information so that you can get on the road to living your best life. So at this time, as I mentioned to you earlier, we have Deputy DeVille. He's going to come to you and tell you a little bit more about the program that Spindletop has to offer.
Thank you, Sheriff. You hit on a lot of it. I appreciate it. Normally, I have my partner. She's a qualified middle level freshman with Spindletop. She's out today, but at least forms that you have on your clipboard, the half sheets, is the questionnaire not mandatory, you don't have to fill them out. It's just some of the services we offer with mental health issues such as use intellectual disabilities. There's a hotline there, 1-800 at the very bottom right. You can get a hold of someone at the office if you need to. You fill it out if you want to. If you want services, put your name, date of birth, just a good contact number, email, however you want to be contacted, by text, in person, phone. And that's pretty much just what I have today. But again, it's optional. You don't have to fill it out. So,
All right, thank you,
Sir.
Deputy DeVille.
yes, sir.
Okay, now, ladies and gentlemen, I also need to mention to you that part of the pretrial diversion program, there's a program that is called anger management. Anger management is for individuals who have just an assault case. Okay, it's not involving a family member. Once you go through that program, they will dismiss your case. Or if you have a case where you have family violence involved, there's another program that is called BIP, BIP, which means Battles Intervention and Prevention Program. With that program, once you go through that program, they will dismiss your case. And guess what? With Battles Intervention and Anger Management, you get it expunged from your record, like it never happened. Okay? So if you're interested in those programs, as I mentioned to you earlier, we have some brochures and some names of some people that can get you started in those programs. All right, now the information that you have on the clipboard, we're going to pick that information up. If you need help with filling that information out, we have our core personnel who's here, including myself, who will be assisting you and we'll be happy to assist you at filling out the paperwork so that the paperwork will be filled out properly. Now, once the paperwork is filled out, we're going to call you up one at a time, and we're going to put you into one of three categories. One category is you want to hire an attorney. If you would like to hire an attorney, your case will be reset today. And you'll be given another court date so that you have time to hire your attorney. The second category is for individuals who will be applying for a court-appointed attorney. If you apply for a court-appointed attorney, if you qualify for a court-appointed attorney, you will be appointed a court-appointed attorney today before you leave. And the last category is for individuals who will be representing themselves. If you're representing yourself, then you'll have an opportunity to talk to the prosecutor about your case. If you are able to work out a plea bargaining agreement, your case will be taken care of today. All right? Now, it's going to take us a little time to finish picking up the paperwork from you after everything is complete. So if you need to use the restroom, there are two restrooms right out in the hallway. We have the men's restroom in front of County Court at Law Number 3, and on the opposite side of the hall, there's a women's restroom, and it is in front of 172nd District Court. You'll be allowed to use the restroom. Please do not leave the courthouse. If you leave the courthouse and your name is called, and you're not here when your name is called, guess what? Your bond is going to be forfeited. A warrant will be issued for your arrest. You will be arrested. You'll be placed in a county jail. And then you have to get back out on bond. And guess what? We'll have to go through this all over again. Okay? So we're gonna try to get you in and out as soon as possible. So be mindful. Make sure that you conduct yourself accordingly. We're still in court. If you have any questions, oh, I always forget to tell you. On the paperwork, it's at the top left-hand corner, it says State of Texas versus, and there's a line. Print your name on that line. And when I say print, print your name, because if your handwriting is like mine, sometimes I can't even read. Okay? So just print your name so we know who the paperwork is for, so that we'll be able to call you up and put you in the right candidate. Okay? So the court is getting ready to go into recess. Please conduct yourself accordingly. And then we're gonna call you up. If you need any assistance, just raise your hand and we'll be able to come out. Or we have you come up, and so we'll be able to help. All right. Court is it? Yes.
This one there?
Yes, right here.
Oh, no.
Yeah, you gotta go out. You gotta go out that one door right there. Yes.
I thought it was the reset.
Till we pick up this paperwork. Yeah, we don't have a particular time. Just put that on that, actually, I think there's a little table. If you can pull that up. Yeah, that thing right there, you can pull it up. Yeah, pull it up to the back, right there. Yeah, you can put that. Yeah. Okay,
If you're done, you can come up here and bring it in your clipboard, just don't leave it. Let me go look over it before you leave it.
Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 26 CCCR 1556. Case is style of state of Texas versus Jorge Torres. Mr. Torres, is that your full name?
Jorge Guillermo Torres.
Jorge Guillermo Torres?
Yes, sir.
Okay, Ms. Torres, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Torres, you may put your hand down. How are you doing, Mr. Torres?
Very good.
You're doing good? That's good. Now, Mr. Torres, you are represented in your case by your attorney, Attorney Charles Rojas, and Mr. Rojas. How are you doing?
Doing well, Judge. Thank you.
You're welcome, Mr. Rojas. Do you waive a record in Mr. Do you waive a record in Mr. Torres' case?
We do.
And Mr. Torres, state is represented in this case by Attorney Samuel Masbranian. Mr. Masbranian, how are you doing?
Doing well, Judge. Thank you.
That's good. Let me hold on a minute. Oh, okay, I see that. Okay. And Mr. Torres, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Jorge Guillermo Torres, on or about February 9th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of driving while intoxicated with an alcohol concentration of 0.15 or more. This information further alleges that prior to the presentment of this information from September 5th, 2024 through August 18th of 2025, an information charging you with the above offense was pending in a court of competence jurisdiction, namely cause number 24 CCCR 2151 in the County Court at Law. It must be County Court at Law number 3, I guess. It doesn't have, it says County Court at Law in Jefferson County, Texas. That doesn't exist. It's either 1, 2, or 3. I'm looking at the odd number. This probably was in 3. Do you know, Mr.?
No, Judge, he was in pretrial diversion, so there was an information pending. This what the.
Oh, it was an information
That's what
pending
the
here,
statute is told, yes.
so it should have been County Court at Law.
Yeah, that would have been 3.
Okay, and it refiled. Let me do this here. I'm going to print this information, and Mr. Masrani, you'd like to make a trial amendment?
Yes, Your Honor.
Oh, I might have printed it to the wrong printer. I didn't know which one it was printed to. You printed?
Yes.
Any objections to the DA's office trial amendment?
No objection, Your Honor.
Okay, it's amended motion, and do you waive any time in which you prepare for trial?
We do.
Okay. Now, Mr. Torres, how do you plead to, let me do it again. I have before me First Amendment information, and in this information alleges that you, Jorge Guillermo Torres, on or about February 9th of 2024, while using Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class A misdemeanor offense of having an alcohol concentration of 0.15 or more. This information further alleges that from September 5th of 2024 through August 18th of 2025, that there was a pending offense in a court of competence jurisdiction, cause number 24 CCCR 2159 in the county court at law number 3 of Jefferson County, Texas, style the state of Texas versus Jorge Guillermo Torres. Mr. Torres, to this information, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes. Yes.
And are you pleading guilty because you are guilty?
Yes, sir.
Okay, Mr. Torres, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document? Speak up.
Yes.
On page 2 of this same document, there's a set of initials on the line next to the box. It's just guilty. Did you place your initials here?
Yes, sir.
And on page 3 of this same document, there's a signature above the line that's titled Defendant. This is your signature.
Yes, sir.
And on the next document, that's titled Trial Court Certification to Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal to your statement. Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. You understand that statement?
Yes,
I
sir.
also have another document that is titled Discovery Certification. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Mr. Torres, before you sign and initial all of the documents that I just showed you, did your attorney go over those documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in those documents true and correct to the best of your knowledge?
They're correct to my knowledge.
Okay, and Mr. Torres, are you a citizen of Jefferson, of the United States?
Yes, sir. I'm a U.S. citizen.
Whoever states one.
Any objections?
No objection.
No objection. States Exhibit Number 1 will be admitted. And Mr. Rojas, you advised in counsel, Mr. Torres, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Torres, your attorney, Mr. Rojas, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Torres, I will accept your plea of no contest, your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
That would be 180 over 1 year probation, 180 days confinement probated for a period of 1 year, a $300 fine, 36 hours community service, interlock installation on his vehicle, and DWI standard terms and conditions.
Ms. Ross, was you appointed in this case?
I was not, Your Honor.
Okay.
Prepping for trial. I need somebody to take over.
Okay, Mr. Torres,
Sure.
the state is offering that you serve 180 days in jail, but you will not be required to serve 180 days in jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $300 plus court costs of $337. You'll be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15. You'll be required to pay a DWI conviction fine fee of $100. You'll also be required to pay Jefferson County DWI education and initial evaluation fee of $100, of $125 on the day of the police. Should a further evaluation be needed, you'll be required to pay an additional $50. Your total monthly installments, that is the total amount that you will be required to pay each month, is $150 a month. Are you able to pay the $150 each month?
Yes, sir.
You will also be required to perform 36 hours of community service, install an interlock device on any vehicle that you own or operate, attend and complete the DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. Mr. Torres, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just?
It is fair, sir.
And do you accept the state's offer?
I accept.
Mr. Torres, I'll follow the plea bargaining agreement that you have entered into with the state. Mr. Torres, you'll stand next to the bailiff, follow her direction. Once you finish following her direction, you're free to go. And you have a blessed day.
You too, sir. Thank you.
Okay, you're welcome, and Mr. Rojas will sign your dismissal on that other case.
Yeah. Oh. Yeah, right, we'll go away and early. Yes.
Oh, I had, Ms. Cooper, would you please raise your right hand and you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Cooper, you may put your hand down. How are you doing, Ms. Cooper? That's good. Ms. Cooper, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant? Or these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature? And Ms. Cooper, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Ms. Cooper, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case is Attorney Albert Price. Attorney Price will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once you get that information, you're free to go, and you have a blessed day. She didn't already do it? Okay. Yeah, just have a seat right there in that first chair on the wall. Deja Thomas. Ms. Thomas. Would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Thomas, you may put your hand down. How you doing, Ms. Thomas?
I'm doing good. How you?
I'm doing fine, thanks for asking. Ms. Thomas, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes,
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
yes,
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
yes, sir.
Okay, Ms. Thomas, before you sign and initial these two documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Ms. Thomas, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinators will give you that information. Once you get the information, you're free to go and you have a blessed day. Please have a seat in that first chair on the wall.
thank you.
You're welcome. John Doucette. Okay, Mr. Doucette, your full name is John Edward Doucette.
Yes, sir.
Mr. Doucette, would you please raise your right hand? Do you swear affirm and tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Doucette, you may put your hand down. How are you doing, Mr. Doucette?
Doing good.
That's good. Mr. Doucette, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this
I
document?
do.
And is this your signature on the line that's titled Defendant?
It is.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Please, yeah.
I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document?
I do.
On page 2 of this same document, there's a signature above the line that is titled Defender Signature. Is this your signature?
That is it.
Mr. Doucette, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
They are.
Mr. Doucette, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in your case, the Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you the information, you'll be free to go, and you have a blessed day. And Mr. Doucette, you can have a seat and wait for your name to be called. Okay. Next case is cause number 26CCCR 4A case is styled in the state of Texas versus, is that a Leo Domingue? Would you please come forward? Mr. Domingue, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Domingue, you may put your hand down. How are you doing, Mr. Domingue?
I'm good, how you doing?
I'm doing fine, thanks for asking, Mr. Domingue. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
And are these your initials on the line state you'd like to apply for court appointed attorney? I also have another document that is titled Jefferson County Affidavit of Injuries. You recognize this document? Would you speak up?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled Defendant. Is this your signature on this line that's titled Defendant signature?
Yes, sir.
Now, Ms. Domingue, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best you know?
Yes, sir.
Ms. Domingue, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney, and the attorney that will be appointed to represent you in your cases, or, your attorney is, Marcus Wilkerson. Attorney Wilkerson will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once you get the information, you're free to go, and you have a blessed day. Please have a seat in that chair on the wall. Miss. Ms. Bussinger, would you please raise your right hand? Do you swear firm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How are you doing?
Good.
That's good. I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
Also, I have another document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there is a signature above the line that is titled Defendant's Signature. Is this your signature?
Yes, sir.
Now, Ms. Bussinger, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney, and the attorney that will be appointed to represent you in this case is Attorney Marvel Provo. Attorney Provo will be given permission to contact you, and you will be given information to contact her. The court coordinator will give you that information. But before she gives you that information, I need to give you some bond conditions. Would you please step to the side of the bench right here? And I'll hand you these bond conditions. You can step back in front of the bench. Okay. Now, the document that you have just been handed is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document?
Yes, sir.
I'm going to go over this bond conditions with you. And it states following return of a criminal information in County Court at Law number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond of any person or any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. You understand that condition?
Yes, sir.
Now, condition number 4 does not apply. That only applies in a DWI case. Your case is not a DWI case. However, condition number 5 on the next page does apply, and it states defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time, paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, if you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in Jefferson County Jail. Do you understand? Just have a seat in that first chair. Wait for your name to be called. Once your name is called, you're free to go. You have a blessed day. Okay. Xavier Collier. Okay. This is cause number 26 CCCR 0328. Case of style, the state of Texas versus Xavier Dominique Collier. Mr. Collier, is that your full name? Mr. Collier? You can raise your hand. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Collier, you may put your hand down. How are you doing, Mr. Collier?
All right.
You all right?
Yeah, I'm all right.
Oh, listen. You're in the land of the living.
Yeah, I know it.
Okay.
But now-
You know, you're on this side of the dirt,
Yeah,
not the other side.
right?
You're on top of the dirt. The dirt is not on top of you.
You're right.
Okay. All right. Now, Mr. Collier, you represented in your case by your attorney, Attorney Todd LeBlanc. And Mr. LeBlanc, how are you doing?
I'm doing good, Judge. Thank you.
That's good, Mr. LeBlanc. Do you waive a record in Mr. Collier's case?
Yes, we do, Your Honor.
Okay. Now, Mr. Collier, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Xavier Dominique Collier, on or about November 7th of 2025, while you were in Jefferson County, Texas, operating a motor vehicle in a public place, that you committed the Class B misdemeanor offense of driving while intoxicated. Mr. Collier, do you understand what you have been charged with?
So,
To this charge, Mr. Collier, how do you plead? Guilty, not guilty, or no contest?
no contact.
Now, are you pleading no contest freely and voluntarily?
Yes,
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, yes.
That's true. Okay. Now, Mr. Collier, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of the same document, there's a set of initials. On the line next to a box says check Nola Continuer. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification or Defendant's Right of Appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled Defense? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have a document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defense? Okay, now, Mr. Collier, before you sign and initial these documents, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes, sir.
Now, is everything in these documents true and correct to the best of your knowledge?
Yes,
Mr. Collier, are you a citizen of the United States?
yes, sir.
State offer States Exhibit 1, Your Honor.
We have no objection.
No objection. States Exhibit Number 1 will be admitted. And Mr. LeBlanc, you have advised and counseled Mr. Collier. Is there any evidence that he is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Mr. Collier, your attorney, Mr. LeBlanc has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Collier, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I'll also find that your plea and waivers was freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
We confine him in the county jail for 60 days, probated for a period of 1 year, the $100 fine, 32 hours of community service, and DWI standard terms and conditions.
Okay. Mr. Collier, the state is offering that you serve 60 days in Jefferson County Jail. However, you will not be required to serve any time in the Jefferson County Jail because you've already served, well, because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you'll be required to pay a fine of $100 plus court costs of $392. You'll be required to pay a DWI conviction fine fee of $100. You will also be required to pay probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15 a month. You'll be required to reimburse Jefferson County Court appointed attorney's fees of $350. You will also be required to attend and complete a DWI education class. Well, you'll be required to pay the initial DWI education class fee of $125 on the day of the plea. Should a further evaluation be needed, you'll be required to pay an additional $50. Now, your total monthly installments, that is the total amount that you will be required to pay each month is $160 a month. Do you understand? Will you be able to pay the $160 each month?
Yes, sir.
Okay, you will also be required to attend and complete, well, you'll be required to perform 32 hours of community service, attend and complete a DW education class, have an alcohol assessment, and adhere to the other standard terms and conditions of this probation. And Mr. Collier, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Okay, Mr. Collier, the court is going to follow the plea bargain agreement that you have entered into with the state. And just for your information, Mr. Collier, your bond that was forfeited some time ago based on the information that you provided to the court, that bond will be forfeiture will be recalled, which means that you'll be able to get your cash bond today, okay?
Okay.
All right, so we've already, it has already been called in, and so what's gonna happen, once you leave here, she'll tell you what you need to do.
Okay.
All right, and Mr. LeBlanc, is this your last case?
That's it, Judge.
You're free to go,
Thank you.
and you have a blessed day. Okay. Yeah, just have a seat, just have a seat and you'll wait for you're gonna follow the directions of the bailiff, okay? She's gonna come over there. Now, Miss, okay, Jefferson County Court at Law number 2 is back in session. Court is in session in cause number 25 CCCR 2022. Case is filed in the state of Texas versus Corey Lee Johnson Jr. And Mr. Johnson, is that your full name?
Yes, sir.
Mr. Johnson, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson? That's good. Now, Mr. Johnson, I have before me two documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
And is this your signature on the line as titled defendant? And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial.
Yes.
Do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Johnson, I also have a document on my computer. This document is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Pearlie Johnson Jr., on or about July 9th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify a fugitive with intent to give false information. Mr. Johnson, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Johnson, how do you plead? Guilty, not guilty, no contest?
Nothing.
Are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what it means. Now, Mr. Johnson, before we go any further, you have a right to have a court reporter to dictate or type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter? You waive it? Okay. Now, Mr. Johnson, I also have before me on my computer tablet a document that is titled misdemeanor plea admonishment, also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes.
On page 2 of this same document, there's 2 sets of initials. First set of initials are on a line next to the box that's checked no contingent, which means no contest as you place your initials on this document.
Yes.
The next set of initials are on a line next to a box that state, I do not request discovery. I waive my right to request discovery in this case and choose to enter a plea of guilty and no contest as you place your initials in the second location. On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
Now, Mr. Johnson, before you signed and initialed all of the documents that I showed you. Hold on. Let me do this. Think about it. Yeah. Okay, there's another document. I have another document that is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case. You have no right of appeal. You understand that statement?
Yes.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
Now, Mr. Johnson, before you signed and initialed all of the documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Johnson, are you a citizen of the United States?
State offers Exhibit 1, Your Honor.
Now, Mr. Johnson, the state is offering State's Exhibit Number 1 to be used as evidence against you in the case. State's Exhibit Number 1 is the first document that you signed on this tablet. I'll show it to you again. It's this document. This is the same document that has your signature in these 2 locations, and it has your initials at the top of this document. Is it all right for the state to use this document as evidence in your case?
Yes.
Okay, no objection. State's Exhibit Number 1 will be admitted. Now, Mr. Johnson, is there any evidence that you are currently mentally incompetent to stand trial? Do you understand, you have any mental issues that are affecting your ability to understand what's going on in this case? You understand everything? Okay. Now, Mr. Johnson, I'm going to accept your plea of no contest. I will find that you are mentally competent to stand trial. I will find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is the agreement?
The agreement is 17 days, time served with court costs, tax, and retired.
Okay, now, Mr. Johnson, state is offering that you serve 17 days in Jefferson County Jail. You will not have to serve any more time in the Jefferson County Jail because you've already served 17 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. That means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Do you understand that? Now, do you understand the state's offer?
Yes, sir.
Do you think the state's offer in your case is fair and just? Do you accept the state's offer?
Yes.
Mr. Johnson, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Johnson, before you go over to the bailiff to finalize your case, you are not here alone. You here with someone, and who are you here with? Hmm? Your girl. Okay. Well, thanks for coming out. And what's your girl's name? Asha? Okay, Asha, thanks for coming down here with Mr. Johnson. Now, Mr. Johnson, you seem to be a pretty young man. How old are you?
25.
25. Guess what? You probably wouldn't believe this, but I was 25 for 365 days. Okay? And when I was 25, I had friends, right? And a lot of times, I know in your day, you have friends too, right? What you call them, your BFF or your ride or die. Those individuals that you believe that will be with you through thick and thin. When you're down and out, they'll be there to pick you up. In my day, we used to call them our ace boom coon. Now, there was those individuals who we felt will be there with us. But on days like today, a lot of times those people that you call your BFF, your ride or die, they're not here with you. And you know why? Because they had something better to do than to be down here with you. But there is somebody that is here with you. You call her your girl. Okay? But Asha, she's here because there was nothing else in this world that would keep her from being here today.
Yes.
You know why? Take a wild guess. Because she loves you. That's right. And I tell young people this all the time. Everybody is not your friend. Everybody's not your partner. But guess what? When Asha says she got you, she got you. Okay?
Yes.
So before the sun set, before the sun go down today, you need to give Asha a big hug and a kiss, thanking her for being down here with you. All right? Now, I'm sure this is not Asha's proudest day to see you here before a judge, but you might even think that your life is in shambles, you're in a storm. But just remember this: when you walking through a storm, hold your head high and don't be afraid of the dark. At the end of the storm, there's a golden sky and a sweet silver song of a lark. Walk on through the wind, walk on through the rain, though your dreams be tossed and blown. Walk on with hope in your heart, and you'll never walk alone. There's one thing about hope: hope floats. So if you're drowning in the sea of confusion, you don't know what to do, just hold on to hope. It'll keep your head above water.
Yes.
Okay? So you'll be all right. Just make sure now, do you live here in Jefferson County?
Yes, sir.
Or you working?
I live on way, but I call.
Okay, we're gonna give you an application to a place at Lamar University. I spoke about it this morning, CICE. They have job training in the hotel industry, the shipping industry, and the chemical industry. Once you're trained in any one of those areas, they'll help you to get a job in the area that you're trained in, okay? With a bailiff will provide that information to you. Just have a seat in the first chair, wait for your name to be called, and you have a blessed day. And Asha, thanks for coming down here with it. I tell people this all the time. Hang on, don't hang up. Okay, he'll be all right. All right. Who else we have?
I'll get the paperwork back. I mean, he has 100.
We just had three.
Judge, do you already have the plea on Mr. Porsche?
Hold on a minute. Yeah, it's. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 26 CCCR 1168, case of style of state of Texas versus Sherman Poche. And Mr. Poche, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Poche, you may put your hand down. Now, before we go any further, Mr. Poche, you have a right to have a record made by a court reporter. You also have a right to waive or give up your right to have a record. Do you waive or give up your right to have a record? Okay, now, Mr. Poche, I have before me 2 documents on paper. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes.
Is this your signature on the line as titled defendant? Or are these your initials on the line that state
Yes.
you would like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document? And is this your signature on the line as titled defendant? I also have a document on my computer that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sherman Poche, on or about April 19th, 2026, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, search, transportation. Mr. Poche, do you understand what you have been charged with? To this charge, Mr. Poche, how do you plead? Guilty, not guilty, no contest? Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charge? That's what no contest means.
Yes.
Now, Mr. Poche, I also have before me a document that is titled Misdemeanor Plea Admonishment, also labeled as State's Exhibit 1. You recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on the line. Next to a box says check. No contender, which means no contest, as you place your initials on this document.
Yes.
There's a second set of initials on a line that next to a statement that reads, I do not request discovery. I waive the right to request discovery in this case, and I choose to enter a plea of guilty or no contest. Did you place your initials on this second location? I also have another document. Well, on the page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes.
Also, on the next document that's titled trial court certification or defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box says check, states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box says check, states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Poche, before you sign and initial all of these documents that I showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Poche, are you a citizen of the United States? State, you like to offer states 1?
Yes. Yes, state offers state exhibits 1.
Now, Mr. Poche, the state is offering state's exhibit number 1 to be used against you as evidence in this case. State's exhibit number 1 is the first document that I showed you on this tablet. This is the same document that has your initials in these 2 locations on page 2, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Poche, state's exhibit number 1 will be admitted. Now, Mr. Poche, is there any evidence that you're currently mentally incompetent to stand trial? Mr. Poche, I will accept your plea, no contest. I will find that you are mentally incompetent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. state do a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
A fine of $800 with jail credit of 2 days to be paid on or by July 30th.
Okay, what's the,
And that includes cost, Your Honor.
okay, the court cost is 287. Okay, and July 30th, 26. Okay, Mr. Poche, state is offering that you pay a fine of $800 plus court costs of $277. Which comes to a total of $1,087. You will be given 2 days credit toward the fine and court costs. So your balance is $887. In this case, you'll be given time to pay it by July 30th, 2026. And do you understand the state's offer? Okay, so you'll be able to pay it by July 36th, is that correct?
And Your Honor, I don't know if there's been any discussion informing him where to pay that.
Oh, well, it'll be right downstairs to the county clerk's office.
Okay.
Okay, now, Mr. Poche, do you understand the state's offer?
Mhm.
Do you accept the state's offer? Okay, Mr. Poche, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Poche, you get your paperwork, you'll sign with the bailiff. Once you're finished with the bailiff, they'll tell you where the payments need to be made. Okay? Okay, you're free to go. John McMillan? Jefferson County Court at Law number 2 is back in session. The court is in session in 3 cases. They are cause numbers 26CCCR 0680, cause number 26CCCR 0681, and cause number 26CCCR 0884. All 3 cases are styled in the state of Texas versus John McMillan or John A. McMillan. Mr. McMillan, is that your full name?
Yes, Your Honor.
Mr. McMillan, would you please raise your right hand? Do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Mr. McMillan, you may put your hand out. How are you doing, Mr. McMillan?
Fine, thank you.
That's good, Mr. McMillan. You're represented in your cases by your attorney, Attorney Christy Cawthon. Attorney Cawthon, how are you doing?
Doing well, Your Honor.
That's good. Now, the state is represented in these cases by Attorney Nicholas Jeter. Mr. Jeter, how are you doing?
Doing well, thank you, Your Honor.
You are. Now, Mr. McMillan, in cause number 26CCCR 0884, I have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, John A. McMillan, on or about March 5th of 2026, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of assault causing bodily injury. Ms. McMillan, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, how do you plead guilty, not guilty, and no contest?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you are guilty?
Yes, Your Honor.
And Mr. McMillan, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments, also labeled State's Exhibit 1. You recognize this document?
Yes, Your Honor.
On page 2 of this same document, there's a set of initials or signature on a line next to a box that's checked guilty. Did you place your initials on this document?
Yes, Your Honor.
And on the next document, the next page of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, Your Honor.
And on the next document, that's titled Trial Court Certification of Defendant's Right of Appeal. You recognize this document?
Yes, Your Honor.
And is this your signature on the
Yes,
line
it
that's
is.
titled Defendant? At the top of this document, there are 2 boxes checked. First box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes,
The
Your
second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
Also, do we have the discovery certification? Also have they're gonna do an audit form that's gonna be attached. Now, Mr. McMillan, I also have before me a document that is titled Discovery Certification. You recognize this document?
Yes, Your Honor.
Is this your signature on the line
Yes,
that's
it is.
titled Defendant? Now, Mr. McMillan, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes, Your Honor.
And did you understand everything that your attorney went over?
Yes, Your Honor.
And is everything in these documents true and correct to the
Yes, Your
best of your knowledge? Mr. McMillan, are you a citizen of the United States?
Yes, Your Honor.
State Office Exhibit 1.
No objection.
No objection, states exhibit number 1 will be admitted. And Ms. Carlton, you've advised in counsel, Mr. McMillan, is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. McMillan, your attorney, Ms. Carlton, has advised and counseled you. Are you satisfied with our services?
Yes, Your Honor.
Mr. McMillan, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what's the agreement?
In 26 CCCR 0884, the state has offered that the defendant will serve 273 days with credit for 118 days time served. And that will run concurrent with,
What's the cost? Okay,
that'll run concurrent with 26 DCCR 0517. And pursuant to that agreement, the state will dismiss 26 CCCR 0680 and 26 CCCR 0681.
okay. What's the court cost?
287.
You have a copy of the affidavit?
The costs were attached, correct, in the agreement? The state
Now,
will-
what's gonna happen is, when he go to the jail, they're gonna see he has additional jail time. And if he has additional jail time, they will tack on, these $287, which be an additional 3 days. And so what I'm gonna do,
Well, I can,
oh, we'll take care of it. It's not a problem.
okay.
Now, Mr.
It's 270.
Okay, Mr. McMillan, the state is offering, just give me that affidavit. State is offering that you serve 273 days, Jefferson County Jail. You'll be given credit for the 118 days that you've already served. The court cost in this case is $277. Are you able to pay the $277?
No, Your Honor.
Okay, that's fine. You have that affidavit?
It's printed.
We'll print the affidavit. That affidavit will be handed to your attorney. She will hand it to you for you to review. That's, well, did he approve it?
Oh.
That's all you gotta do is look at the, if he approve it, it's, yeah. He got a signature on board, he didn't, okay, let me see. Could you, take a minute to fill out, if he doesn't have any. Maybe when I have before me a document that is titled Affidavit of Indigence, do you recognize this document?
Yes, Your Honor.
Now, is everything in this document still true and correct today?
Yes, Your Honor.
Okay, Mr. McMillan, the court is gonna find that you're indigent. And pursuant to Article 42.15 of the Texas Code of Criminal Procedure, the court costs in this case will be waived. Okay? Which means you won't have to pay it. All right, now. Mr. McMillan, do you understand the state's offer and the findings that the court have made in this case?
Yes, Your Honor.
And do you accept the plea agreement?
I accept, Your Honor.
Okay, okay, Mr. McMillan, I follow plea bargaining agreement that you have entered into the state. Mr. McMillan, you're gonna stand next to the bailiff, follow her direction. Once you finish following her directions, you'll be free to go and follow the bailiff, and you have a blessed day. All right.
Maybe excuse her?
Yes, Ms. Coffin, you may be excused. You have a blessed day as well.
Take her.
And Mr. Jeter, you're excused as well. You have a blessed day.
Thank you, Your Honor.
And
Yeah.
what about, we had Cole and, Delage. Do we know what happened with those, with their cases?
Oh, reset on their felony,
A reset?
yes.
So the felonies were reset, okay?
Yeah.
And let's see.
We have bond forfeiture.
Yeah, we have some bond forfeitures.
Oh.
Did we check the bond forfeitures? We have Charlotte Barber, a note on Barber? I don't have a note. On BR,
Cause I know
Who's talking to me?
me.
okay, we still can forfeit the bond.
You should put NIC. NIC.
Okay,
NIC.
okay, this is clause number 26 CCCR 1088, case is filed in the state of Texas versus Charlotte and Barber. Ms. Barber was scheduled to be in court this morning at 9 AM. At about 9 AM, the court's bailiff called the name of Charlotte Barber at the courthouse door. Charlotte Barber did not answer. She has not appeared in court since the court has been in session. The time now is 12:22 PM on today's date of June 30th, 2026. Ms. Bailiff, would you please call the name of Charlotte Barber at the courthouse door?
Charlotte Barber, Charlotte Barber. Notify John.
Charlotte Barber's name was just called again at the courthouse door. Charlotte Barber did not answer. Reasonable time has passed to give Ms. Barber an opportunity to appear in court. She has not appeared in court. State, do you have a motion? You moving for bond forfeiture?
State makes a movement for bond forfeiture, Your Honor.
Okay, Charlotte Barber's bond will be forfeited and a warrant should be issued for arrest in cause number 26 CCR 1088. Next case is cause number 26 CCR 0944. Case is filed in the state of Texas versus Latrina K. Burton. Latrina Burton was scheduled to be in court this morning at 9 AM. At about 9 AM, Latrina Burton's name was called and Latrina Burton did not answer. The time now is 12:23 PM on today's date of June 30th, 2026. Ms. Bailiff, would you please call the name of Latrina Burton at the courthouse door?
Not a good address, Joe.
Oh, it's not. Well, you can strike that. It's not a good address, so we won't be able to forfeit that. vote.
yet.
Oh, okay.
Okay, so that was, okay, what about the next case? Kentavian Lede, cause number 26 CCCR 1192. Kentavian Lede was scheduled to be in court this morning at 9 AM, at about 9 AM. Of course, bailiff called the name of Kentavian Lede at the courthouse door. He did not answer. He has not appeared in court since the court has been in session. The time now is 12:24 PM on the day's date of June 30, 2026. Ms. Bailiff, would you please call the name of Kentavian Lede at the courthouse door?
Contavian Lede. Contavian Lede. No response, John.
Okay, Kentavian Lede, name was just called again at the courthouse door. Kentavian Lede and then I'd answer. A reasonable time has passed to give Mr. Lede an opportunity to appear in court. He is not appearing in court. State, do you have a motion? for
Yes.
the bond?
The state requests that the bond be forfeited.
Okay, that motion will be granted. Kentavian Lede bond will be forfeited in Warrenshire Beach arrest and cause number 26 CCCR 1192. And this will conclude the calling of the court's arraignment docket on today's date. June 30th of 2026. County Court at Law Number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day. Court will be in recess until 1 o'clock for our pre-trial motion on the trial that we have at 1:30.